Thank you. If it may please the court, Michael Nam.
Wait a minute. Just going to set the clock.
Oh,
No, you want to turn that, see, here's
This
this
is your
clock.
clock.
You look
Oh,
at
I'm
this
sorry.
one, we look at that one.
all right.
Okay,
Very good.
all right.
Thank you. May it please the court, Michael Nam Crane for Mr. Doe. I would first point to the statute in this case where the legislature has provided for what situation a petitioner would default his right, he would give up his right to a hearing, and the legislature is very specific in that.
B178L2, that one?
L1C and L2, yes, Your Honor. And in that regard, the legislature has already spoken as to what it intended as far as when a petitioner would give up his right to a hearing. It has no other provision that permits the board to summarily classify a petitioner who is represented by counsel at the hearing. And so given that lack of explicit grant of power, the question remains, is there an implicit power reasonably necessary to implement the statute? And I would submit that the answer is basically in the board's brief, and that is there is no reason. The board provides absolutely no reason as a matter of practice or law why it needs to default people when their attorney is there ready to go at a hearing.
Let me ask you this question. You would agree that the statute overall, and I'm forgetting the particular section, gives the board broad authority to promulgate regulations to implement the statute? Correct?
Certainly, yes.
And would you argue that it is either arbitrary or ultra-virus for the board to have a regulation that says we want the sex offender at the hearing?
I think in this context it does, because first of all, the legislature has already provided for a situation where it would find somebody's waived the right to a hearing.
No, I'm not talking yet about default. I'm just talking about their regulation that says, I'm not yet at the consequences,
Right.
Just the point that we are requiring that the sex offender attend in person, even if he or she has an attorney or another authorized representative. We want that person there. That's not irrational, is it?
Well, if there was a reason, which there isn't. I mean, they have to say no reason why it's necessary that the petitioner be there when he's already represented by counsel. If you understand the way these hearings work, they're basically all on the paper as far as the board is concerned. They never call a witness. They only present a stack of paper. So they never present any exhibits other than the paper. They don't present witnesses. The only utility that the petitioner's presence would serve is the petitioner if he had chose to testify.
Are you suggesting perhaps an analogy to another circumstance which also is civil in nature but also could deprive individuals involved in the proceeding of an important right, such as termination of parental rights? In those proceedings, they go forward notwithstanding the absence of a parent. And notwithstanding that absence, there's a requirement that the court issue findings with respect to any consequence or adjudication of termination.
Right.
And in looking at this statute, which appears to come from, I can't remember the date, but the John Doe case, that also seems to rely, at least in its reasoning, for the standard as being not clear and convincing, a lesser standard, the assumption that there will be findings. So are you suggesting that taken together, unless there's a reason such as we need to have testimony, which is not set forth either in the statute or in the case law that apparently was the genesis of the statute, that the remainder of the statute is what governs? That is, you can provide documentary evidence, that's in the statute, you can have an attorney, that's in the statute, and there has to be an adjudication, implicitly findings to support it.
I would agree with that analysis, Your Honor. And I talk about that in the sense that I harken back to the Superior Court's decision in this case, where he notices the fact that he has absolutely no idea why they reclassified him from a 2 to a 3. And there's no.
She.
Oh, I'm sorry, she. I apologize. She has no idea why that was done. And because the board didn't provide, as it would normally do, and it should do under the standing order of the Superior Court, a record, an administrative record, all it did was provide an answer that you would have in another case, you know, that denies or affirms or whatever the assertion of the complaint. And so we don't know why that happened. And you're right, it's troubling because in this particular, most importantly in this context, both as a matter of due process and also as a matter of public safety, we have these decisions, how to classify somebody, should have some basis. We should know the reasons why they did that. There should be an individualized examination so that we can trust the results of that.
I'm not sure yet whether I'm right. I just wanted to make sure I understood.
Yeah.
A question about the facts. With respect to that portion of the statute that says you can provide documents, what do you understand that? What do you say that that means? And did the petitioner in this case attempt to introduce documents?
Yes, I think if what record we have, it's clear that his counsel had submitted to the hearing examiner that the case should be decided on the papers if they ultimately decide that the petitioner has defaulted. And the hearing examiner didn't want to do that. She said, I'm not going to do that.
Proffered the documents.
Yeah, proffered the documents. And to me, it seems only, I mean, if we want to have an accurate decision, and there is information out there that would be material to that decision, having ignored it doesn't serve anything. I mean, it serves no purpose if what the goal is, particularly under the statute and this Court's own precedent, the goal is to have an accurate decision, an individualized decision.
So is your point, maybe, it's not so much the idea that it's irrational to require the petitioner there, it's that if the petitioner doesn't show up and counsel is there, or maybe even if counsel isn't there, the board, the petitioner having asked for a hearing, the board has an obligation to provide a record of what it is that's justifying its, in this case, decision to reclassify, and that that the petitioner, even though he didn't appear, could appeal that, whatever the decision is that comes out of that record, could appeal that to the Superior Court. Is that?
Well, I mean, that would certainly be preferable than what's happened here. I'm not, we don't have the case where in this case where the attorney doesn't show up. So I think, I think here we would at least want the attorney, that the fact that the attorney did show up, a representative of the petitioner, I think gives more credence. But yeah, I think you're right. I mean, that would not be a bad idea to have to ask the board to please tell us why you decided this way so that we have some faith in these decisions.
May I ask you a hypothetical?
Certainly.
On the papers, it says that the defendant resides in the town of Revere, but actually they've moved from that to another location, and the board doesn't know that. So they make their decision based on the information that they think is current, but it's not. Now, if the person was there, they could confirm that. That would be a rational reason to require them to come to the hearings, wouldn't it?
It would if I had ever heard them actually calling the petitioner as a witness. If they ever would require.
I'm saying if they had a question,
right,
having the person there to confirm address, employment, treatment, they could get that information.
Well, they certainly can get. Well, yes, that's very true, and they certainly can get it from his attorney as well. And since he assigns his attorney to go to the hearing, and the attorney would presumably have that information from his client, the attorney can very well provide that to the board. So there's no reason necessarily to have the petitioner even in that case, because his attorney is there to give it that information.
Let's assume you are right, that there should not be a waiver. What rights are waived by the failure to appear at a hearing?
Well, certainly, I would think your right to testify would be waived. But essentially, I mean, there are some rights under Chapter 30A, such as quasi-confrontation rights and things like that, but those can be all exercised by your attorney. That is, calling witnesses, confronting the evidence against the petitioner and things like that. Certainly, you would have the petitioner would be able to consult with counsel at the hearing, and in that regard. But if he doesn't show up, then I think his attorney is fairly able to go forward without him.
Well, what if he isn't? So what happens then?
What if the attorney isn't?
What if the attorney isn't ready to go forward?
Well, I mean, the attorney would speak up and say so. I would imagine. If there's some piece of information or some sort of...
So attorney says, I'm not ready to go forward, and the hearing examiner says, we're going to determine whether there was good cause, and based on what we've heard, there's not good cause. So then is it waived?
Well, first of all, that's not before us, but certainly that might be true. If the attorney says, I'm not ready to go forward, and I need my petitioner here, and the petitioner has surrendered his presence, that might be a case which is not before us where that might be reasonable. But again,
You mean in a case where he or she, the attorney, doesn't also have documents, or has documents that says, but I need my client and I don't have.
Yeah, I think
him or
that's.
her?
I think that's right. I think that's probably a better point in the sense that it's something from the
I'm
client.
asking the question.
Yeah, I mean, if something from the client that the attorney needs and the client hasn't provided it, that might
Who
be
has the burden in these?
that the board does.
Right.
For preponderance of the evidence.
So,
Well,
Would it be unreasonable if the petitioner doesn't show up to put the burden on the other side? I don't know.
No, I don't see any reason for that. The board only presents its cases as basically a stack of papers, and it, routinely makes its burden supposedly based on those papers.
if
the defendant or if the petitioner is in a situation where he would like to have challenged some information that was contained in one of the documents, and if he were there, he might have been able to get up and testify contrary to what was in a document, that something occurred. He essentially gives up the right to present that defense, it would seem to me.
Well, yeah, I mean, obviously, since he's not there, and if he hasn't informed his counsel as to that concern, then
Even if he did inform his counsel, if he's not there and he doesn't have good cause for being there,
I think that
or good cause for not being there, isn't he just like any other witness in that sense?
certainly. I would sense that there's a couple of the considerations, though, to your point and Justice Cordy and Justice Duffley's point, in the sense that these petitioners also have the right to effective assistance as a counsel, so that if there's something that's going on at the hearing that the petitioner's attorney is not able to go forward, claiming that he's not prepared.
Well, my concern
or is not authorized. Is the attorney now going to have to get sort of an authorization, which, I show up, am I authorized to go forward without my client?
I think routinely attorneys waive their client's presence when they believe it's necessary to do so, when they're prepared to go forward. That's a discretionary call by the attorney.
I understood the question, and maybe I misunderstood it, but or maybe this is my question then, that you can be present and maybe understand that your client would have liked to contest, but for reasons not known to you, as in this case, for example, a recent accident, client doesn't show up, or maybe it's not a good reason. But that's just an opportunity. The petitioner has given up the opportunity to contest, not, you're suggesting, the opportunity to have an adjudication on the documents submitted pursuant to a request for a hearing and findings.
So, yes, I would agree with that, Your Honor. Certainly, he would not be surrendering the right to a hearing. He certainly might be surrendering things that would be incompetent with his presence. He may be able to confer with counsel and things like that. But, again, there's no evidence that there is such concern in this
I take it the
case.
hearing in this scenario is basically the board, I'm sort of going with what you say. The board submits the documents it wants as exhibits. They're all documents. They have no witnesses. You have no witnesses because, well, you don't, presumably because your client isn't there and maybe there's nobody else. And that's the end of the hearing, right? It's basically a hearing to accept documents.
Well, it's a little more than that. In the context of the hearing, there are you can have both sides presenting their cases on the papers, essentially, but there also there's opening and closing arguments, and there's discussion regarding sort of reliability concerns and things like that of the various exhibits. Whether, like for instance, you have like a police report that may have some passage in it that doesn't have an indicia of reliability, that can be raised.
So it would be an argument about its admission?
Yes.
Counsel, your time is up.
Thank you.
Thank you.
Good morning, may it please the court. After requesting a classification hearing to challenge a recommended level, the sex offender has one of two choices. He can appear at the hearing that he requested, or he can seek a continuance pursuant to the regulations. In this
He
case,
only have those two choices?
Yeah.
I'm sorry, he can appear at the hearing.
No,
Yeah,
but
why does he only have those two choices? The
Those-
statute doesn't say he only has those two choices.
Those two choices are set out pursuant to the regulations. The board is explicitly granted the authority pursuant to Section 178L to promulgate regulations to guide the hearing process. And specifically, the statute says, once the sex offender requests a hearing, the hearing examiner appointed by the board shall conduct the hearing according to the standard rules of adjudicatory procedure or other rules which the board may promulgate.
What is the rationale for the rule that you have that requires a petitioner who is represented by counsel to be personally present?
It's important to the board, as was pointed out, I believe, by Chief Justice Ireland. It's important for the board to have the offender there. They've made that point clear in their regulations.
I understand they have, because that's their regulation, but why?
Part of it is for to answer questions from the sex offender. Oftentimes, even if they don't testify, there are questions that arise with regards to factual issues. Where is he living? Where is he working? Those types of issues. Those are also part of his registration obligations. So to have him in front of you to assess that. And there are circumstances where a sex offender may not intend to testify, but perhaps something comes up during the hearing process, during an opening argument, or something is brought up to which they want to respond. If he's not there, he doesn't have that opportunity.
Oh, but that's his choice. If the agency has questions, couldn't they just say, wow, we didn't think of this, let's pause and get to the petitioner here? As you pointed out, questions about, there's no allegation here of failure to register. All of those things would be information about where he lives are on the registration. If there's an issue about it, I assume the department would have it as its burden to show that there was an issue, and that would add to the claim of the level. So, what is, if we were to say that he's not necessary to be there because nothing in the statute says it, what is lost? What opportunities are lost to the department, to the agency?
I think assessing the appearance of the offender in front of them during the hearing process. I think that's a big part of the process, regardless of whether or not he testifies. But I think there are often times when questions come up, and only the offender knows the answer to them. His attorney quite often doesn't know the answer. It's not efficient, and it would sort of disrupt the entire system if something were to come up and say, oh, well, now we need to wait for the offender.
So
I'm sorry.
I'm sorry to interrupt you. So you're saying questions may come up beyond the paper pleadings, the documents.
Oftentimes they do, Your Honor. Oftentimes things come up.
And you said assessing the petitioner, you're talking about the demeanor of the person on the day of the hearing?
Yes, Your Honor. That's exactly what I'm talking about. Even if they don't testify.
Is that a factor that the board can take into account?
I think it would be considered to the hearing examiner would be able to consider that if you
What
have.
the person looks like? I mean, let's assume he doesn't open his mouth.
I'm thinking more demeanor, Your Honor. In certain circumstances, we've had hearings where the board puts on its case, they do their opening and closing, and the sex offender gets quite outraged. He's pounding the table. He's getting angry because he doesn't like what's being said about him. I think that's an important part of the process, in which may, in fact, even lead him to now want to testify. And if he's not there, he doesn't know what's being said about him. The hearing examiner doesn't have that opportunity to give that evaluation.
Is there any regulation which says that his demeanor is to be a factor in terms of his likelihood of sexual recidivism?
There's not a specific regulation, Your Honor, but I do think that's an overall part of assessing a person in front of you.
I've read many of these. I've never seen anybody say that the appearance of the individual or his conduct at the hearing spoke to his sexual recidivism. Have I missed that? I mean, are you saying that you are aware of situations in which the hearing examiner has said, this fellow seemed to get angry, therefore he's more likely to commit sexual crimes?
There have been cases, perhaps they haven't made their way through, but I am aware of certain cases where offenders have reacted in a certain way, and the hearing examiner has written that into their decision, as in their conduct suggested that they were disputing what was being said or a sense of denial of what happened. And I think those things do happen at hearings, but I think it's important in these cases, given the nature of this type of hearing, for those offenders to be there.
Well, let me just move on. Let's assume that's okay. Offender isn't there, and under your regulation, it treats the offender who has, or the petitioner who has requested a hearing exactly the same as one who has not. You say by regulation, I don't know what authority you would have to do this, but you say it, you have no right to judicial review. You are exactly in the same boat as though you had not requested a hearing. And what is the, I guess I'm wondering where that authority comes from for you to waive judicial review on the part of petitioners.
I think it comes from, as we were saying, discussing earlier, that the board does have the authority pursuant to the statute to promulgate regulations with regards to the hearing. With that authority, more than once in the regulations, they made it clear that if you don't do one of the two things, to show up for your hearing or to request a continuance, which this petitioner did not do, you are deemed to have waived your right to that hearing. If you waive your right to the hearing, then you also waive your right to judicial review, because essentially there's no adjudicatory proceeding. Nothing took place.
Well, something
to
took
be
place
reviewed.
here.
Yes, something did take
Didn't it
place.
go from a level 3 to a level 2?
The other way
No,
around.
2, 3.
2 to 3.
Or 2 to
Yeah.
3?
Yes, he was previously classified as level 2 offender, and then he was being reclassified as a level 3.
Without a hearing?
Without it, well, he was
It's-
given the hearing, Your Honor. He
Well,
chose not to come.
Well, he's treated the same way as somebody who did not request a hearing, isn't he?
Yes.
Somewhat, Your Honor.
Well, it's more than somewhat. And you're saying that he has no right to judicial review of the increase from 2 to 3?
That's what we're saying, Your Honor. If he had come to
So what was the basis of, if he had not requested a hearing, he would have been classified as level 2?
If he had not requested a hearing, he
level 3.
would have been classified
Yeah.
as a 3.
So he, by not showing up, he became a level 2 offender.
3.
He became a 3.
All right. It changed, right?
Right, it
His
changed.
classification changed.
Yes, Your Honor.
And then he has absolutely no right of judicial review to the reason for that change?
Well, he had the initial right to challenge that at the hearing, but he didn't come to his hearing. So where then why would he have a right to then judicial review if he didn't come to the administrative hearing in the first place to challenge that level 3
Because the
classification?
statute does not take away the right. I mean, why can't there be a review of the hearing, and you have some obligation to put in the evidence on which you have changed his classification?
There was no hearing for there to have evidence put in.
There was a hearing. There was a hearing officer, there was his lawyer, there was the board's person. They're all there.
But there was no hearing, Your Honor, because
So what was the
offender wasn't
rationale?
there.
What was the
Sorry.
rationale for the change in classification?
Unfortunately, Your Honor, it's not in the record because he wasn't at the hearing, so there was no administrative record.
Was there any intellectual process that occurred and recorded?
Your Honor, yes. What happens in a reclass, very similar to a classification, when the board is made aware that there is, in this case, some reason to reclass, they go through the entire regulatory process with regards to the pre-class process. So in this particular case, he would have been sent notice that they were going to reclass him. He was given 30 days to send in any documents that he wanted the board to consider at that point of whether or not they should reclass him. And then after the board looks at all the information, they determine whether or not they're going to class him from a 2 to a 3. And in this case, they did. And then he is sent notice of that information as to why they were reclassing him.
He
At which point
gets notice and a basis for the
he does, Your
has
Honor. And again, unfortunately, because there was
it's not just notice, but
Yes.
also the supporting documentation for the reclassification?
Yes, Your Honor. What's sent to him is it's been referred to in several cases as a classification worksheet.
So is it the same things that would have been submitted had he shown up at a hearing, these exact same documents that the hearing officer would get at a hearing?
Yes.
Is what this individual got?
Yes,
Okay.
he also, I'm sorry, did I cut you off?
No.
Are those documents in our record?
Those documents are not in your record, Your Honor, because there was no adjudicatory proceeding that took place that those records were submitted.
Were they presented to the Superior Court judge?
No, they weren't, Your Honor.
So there was no record of an administrative proceeding before the Superior Court judge?
Correct, Your Honor, because there was no proceeding based on the offenders not showing up.
I mean, why shouldn't we simply say that when one requests a hearing, one puts SORB to its proof? And if you don't attend, SORB can show its proof, and then if it's sufficient, it'll be upheld, and you lose your right to confront, to be there. You lose your right to testify. You may even lose certain rights as to whether or not counsel was effective because you were not there to assist counsel. Why is that not a more sensible result, more in keeping with the statute than what you're proposing? I mean, the analogy I guess I'm troubled about is that in a criminal case, in those few times in which we say the trial may proceed without the defendant there, we don't say the defendant loses his right to the government to be put to its proof of proving guilt beyond a reasonable doubt. You waive certain rights, but the government still has to prove you're guilty beyond a reasonable doubt. Why is it different here?
I think, well, first of all, it is not the criminal setting. It's an administrative setting. And in a criminal case, there's a different standard of proof for starters, but there's also a different process pre-hearing. And in this particular case, the board's already made its pre-classification decision. And he's given ample notice that if he wants to challenge it, he can. If not, he has two options. He can have his hearing to challenge the classification, but that essential level has already been made. He either challenges it or accepts it. And by not coming to the hearing that he accepted, with ample notice of what would happen if he didn't come to that hearing. It's when he requests his hearing, he signs an affirmance saying he understands that if he doesn't come to the hearing, the recommended level will be made final.
Is that before us?
That is before us, Your Honor. That is in the addendum at pages 161 and 162.
But
That's
the
because
recommended
the-
level was not made final.
The recommended level was made final. He was recommended as a level 3. He didn't come to his hearing. He was finally classified as a level 3.
But he signed that. That's what your regulation requires. But the challenge here is to the validity of the regulation. So, I mean, I don't see why that binds us in some way.
Because I think the regulation, I think the board is authorized under the statute to make that type of regulation that he's required to attend. And if he doesn't attend, these are the consequences, or this is what the end result will be. It is essentially waiving your right to a hearing. That's how it's put out in the regulation. Now, given that the legislature gave the board the broad authority to promulgate those types of regulations, it certainly is reasonable to require an offender to be at the hearing that he requested, and if not, then the recommended level that he's been made well aware of would become final.
Now, can I ask you this? There was an adjudication here, though. There was an adjudication that there was not good cause. Is that appealable?
It's not appealable under the 30A, Chapter 30A, because it wasn't an adjudicatory proceeding, in the traditional sense. There was no testimony, there was no sworn statements.
Pretty important decision, and it was based on submissions of the parties.
It is a pretty important decision, Your Honor. I don't disagree with you.
Completely eliminates his right to challenge this very onerous classification. So why isn't that appealable in some format?
As it was stated, Your Honor, Chapter 30A requires an adjudicatory proceeding, and there was none in this sense in the terms that are used in cases.
Yes, there was. It's just that it didn't have witnesses. But everybody was there. It was a hearing. It's just that the contents of it are different than a lot of adjudicatory proceedings. I mean, one could look at it that way.
My apologies, Your Honor, but there was no hearing. Everybody was there, but nothing happened on that day. Nothing went forward. There was no evidence.
Maybe the point is that it should have. It was a hearing, and there were documents on which this decision should have rested. And so the analogy, you say, shouldn't be like criminal, but I'm going to go back to one I suggested earlier. Maybe it's more like termination of parental rights, where an agency says you shouldn't have your children, and they act consistently with that. They notify about that. There's a right to a hearing. If you don't show up, there's still a hearing. Documents are still presented, maybe witnesses, and then there's a consequence, an adjudication, but there is review. Isn't it like that?
I don't think it is like that, Your Honor. I think there's a little bit of a difference in terms of your right to have your children as opposed to the interest that's at stake here. And although it's an important right, it certainly isn't raised to the level of a fundamental right of raising your children. I think that it is a difference between the two processes that, in this particular case, makes it okay that you're making this decision in the manner that it was made, and it essentially is being made ahead of time, and he is notified of his level 3, and he has the right to challenge that. And by virtue of the regulation, by not coming to that hearing, he's waiving his right to challenge that.
Actually, John Doe, which is John Doe, the 1998 case, which preceded the amendment to the statute that we're talking about, talks about the analogy between termination proceedings and these proceedings, and discusses why there is going to be heightened scrutiny, although not at the level of changing the standard, but by requiring the fact finder to make particularized, specific, and detailed findings guided by factors in 178K. It doesn't say only if the petitioner shows up, right?
It does not, but that version of the law also didn't allow petitioners to have hearings. They were making decisions without any hearing whatsoever. And part of that analysis is that they have to be given that right and that opportunity to challenge that classification level at a hearing. He was given that right. He was given that opportunity. He opted not to exercise that. He didn't avail himself of that opportunity.
Counsel, your
If I
time
could, I'm
is up.
sorry, just with regard to Judge Cordy's question, if the facts here were a little bit different, and if in fact he was in the midst of heart transplant surgery on the day of the hearing, and the hearing examiner said, I'm sorry, he still should have been here, he should have rescheduled, no appeal.
I would doubt that would be the end result of that, Your Honor. I think if you look at
Basically, if it was an arbitrary and foolish and unfair denial of a continuance, there's still no appeal.
There would still be no appeal, but I do think that if you looked at the good cause standard in the regulation at 803 CMR 1.12, it lays out what the hearing examiners considered there would be the amount of time of notice for the hearing, the ability to anticipate the circumstances which resulted in his inability to appear, and the delay by the sex offender in notifying the board.
And we have appeals to ensure that those standards are in fact used by individuals who make decisions of that sort.
There are, but I do think that when you look at it in this particular case, even if you were going to review the good cause, this particular offender is not going to pass that standard. There were 12 days in between his injury and his hearing, and he did nothing.
I understand this case is this case.
Thank you, Your Honor.
Thank you, Counsel.